Hey everybody, I'm Craig Valine, and today I'm here with 30-year veteran IP attorney Dan Kimbell, and we're covering topics on protecting your IP. And Dan, thank you for being here today. But one of the questions that I have are about registered trademarks, are they worth the trouble and expense? Because sometimes I bump into entrepreneurs and inventors, and they balk when they find out that it actually costs money to have an IP attorney help them obtain registered trademarks. So can you tell me why inventors should protect their trademarks with registrations?
Absolutely. Yeah, there's so many reasons. I'll give you today a baker's dozen, 13 reasons why you really should do that. First of all, number one, first of all, getting a trademark discourages others from trying to get the same mark, either the same one or a confusingly similar mark. So if you have a trademark, somebody may just decide not to try for it. So that's one reason you keep potential competition at bay. Second reason is related. It's protecting against registration of the same or similar marks. So when you file for a trademark application, or somebody files for a trademark application, the trademark office, an examining attorney looks at the trademark register for pending marks and registered marks. And if they find that there's something that's too close, they'll refuse registration. So that's another benefit that you might not have another potential mark get registered because the examiner will search and refuse to register. Another important reason, which is somewhat related also, is it treats a mark as if there's nationwide usage as of the application date. So generally, if you have a common law trademark, you don't have a registration, but you have rights because you use it in a geographic area. That benefit only gives you protection in the local geographic area. So if you have a pet store with a certain name and somebody tries to open a pet store with the same name or a similar name down the street, you'll be protected. But if they tried to open a pet store across the state or in a different state on the other side of the country, they could do that. But if you have a registration or an application pending, that actually gives you protection in the whole country. So if you ever want to expand, having a registered trademark and an application pending is really great. And another, thing is once the application is registered, it provides nationwide notice to prevent others from adopting the mark in good faith. So once you have a registration, if somebody were to try, they can't say, I didn't know about you because your mark is registered. It's easier to find out.
Right.
Any questions so far, Craig?
No, you're making a lot of sense, but I can see why that would be valuable because I have been, I live in LA and I've gone home to Boston and say, hey, there's a store just like that in LA, or I've seen a book or, copyrights, things like that. You see same titles and like, how are they able to do that? Well, the first author might not have actually protected themselves.
That's right.
Or this person is ripping them off by not doing their research and, publishing it anyway. So
yeah, that's an example. Like people think it's related to you. It's a source indicator. So that's one of the benefits if you do have the registration. So I'll continue. We'll give you some more of this baker dozen. Fifth reason, it serves as evidence of the validity and exclusivity of the mark for the exclusive ownership of the mark for goods and services listed in the registration. So that basically, in layperson's terms, if you have a registration, it's assumed valid for whatever you have in the registration. Another related thing is after 5 years, you can actually apply to have the mark ruled incontestable. So basically, you make this application. It's called a statement of incontestability. So you file the statement when you renew, between the 5th and 6th year. And basically, if you get it approved, which is pretty straightforward, no one can challenge your trademark except for a very few narrow reasons, like if you commit fraud in the patent office or something. Right. So that's really makes your trademark extra iron-proof, bulletproof. Sixth reason, it gives you the right to use the registered trademark symbol, the R in a circle. You see that all over the place. So when people see that, it gives you, cachet. It looks like you're a big company if you have a registered trademark. So it's kind of important to have that from a marketing standpoint. The alternative is you see a little TM sometimes. That just means the mark hasn't been federally registered, but maybe there's an application pending. You can use a TM before the application is registered, but our inner circle is after it's registered. A seventh reason is it gives you rights to sue in federal court. There's something called the Lanham Act, which offers protection. So if somebody is infringing, you can go to your federal court as opposed to a state court. Federal courts are much better equipped to deal with trademark violations in general than state courts. So from a litigation standpoint, federal court's the way to go. Another thing related to lawsuits, it gives you a statutory right to damages in cases of counterfeiting. So if somebody sells counterfeit goods, you actually have a statutory right to stop them for counterfeiting, and it relieves you. That's the word I was searching for. It relieves you from having to demonstrate actual damages to get at monetary damages, because sometimes it's hard to prove your damages, but just by virtue of having the registration, if somebody counterfeits, you can get damages without proving how much they are. So that's a big benefit. If you're suing somebody and they have that hammer over you, you don't want to be in the position where you have a hammer over you. So it's a great thing.
Right.
A ninth reason, which is important, it provides a basis for foreign trademark registration. So in this world, you get a brand in the US, it may be picked up somewhere else, like in China. It's very common to have trademark squatters. If you have a semi-famous brand in the US, for sure some Chinese company will file for it and try to, lock up rights in case you want to go to China. Then you're going to have to deal with that. So it actually gives you a 6-month window after you file a US trademark application to go ahead and file foreign. So in this world where there's so much trade, having that right is really important. That if you didn't have a federal trademark application pending, you wouldn't be able to do that. So it's very good. Any questions at this point? Before we go to the finishing line?
Yeah, regarding number 6, where you said grants the right to use the registered trademark symbol. There's rumors on the internet from many of the gurus that say all you have to put is the copyright symbol or the TM symbol and you're covered. For let's say for any intellectual property that they've created. So it could be an article, could be a white paper, could be a course or whatever. Is that true? I mean, if they put down all rights reserved or copyrighted, or haven't done the work yet.
Yeah, copyrights are very different. Copyrights, you automatically have rights without applying. It's just that you can't sue, but your rights are there. In order to get copyrights, you actually have to have a registration issued. So you can accelerate. You can get one if you pay extra money. You can get one pretty quickly in a few days. But that's not the case with trademarks. Patents you don't. For trademarks, you have common law rights, but you don't have these enhanced rights we were talking about now, unless you actually go to the trouble of filing for a federal trademark. So
it's kind of a sense
of benefits of that.
It's a sense of what's the word? It's not real comfort. It's kind of a distorted comfort by putting those things that versus actually getting and registering them and doing the right thing, right?
Yeah, it's kind of one part of the urban myth about, you mail a letter to yourself and that's right. Don't open it. It's just a lot of urban myths about IP. This is one of them, but these are the reasons why. So let me go to the home stretch and give you the last few reasons. There's another benefit, government benefit. If you get a registered trademark, you can actually register it with the U.S. Customs and Border Protection. So this is very effective. So if somebody tries to import goods, bearing your trademark, Customs and Border Protection will stop them. And believe me, I've been there on the other side. It's extremely hard for them to get it lifted, and they will seize your goods, and you basically will lose them and have to pay them to store your goods and then destroy them. So you don't want to be in that position where somebody said you're infringing their trademark. So if if you have a trademark and you think there's foreign competition who might try to sneak products in, you can register it with the Customer and Border Protection. That's extremely valuable. Licensing and franchising opportunities. If you have a registered trademark, it's an intellectual property. You can actually license it. You can franchise it. You can sell it. You can borrow against it. It's an asset, just like other kinds of IP. So it's very valuable to have a registered trademark. If you don't have it, it's kind of like amorphous. Like, what rights do you have? It's just something common law. But how do you prove that? It's so registered is the way to go. Almost at the end, brand recognition and consumer trust. You know, we all know when you like a product, you buy it. Like, for example, Under Armour, it started out with just a few items, and now they sell all kinds of stuff. And if you like one item they sell, when they expand to related fields, you say, "Oh, I like the Under Armour T-shirt, so maybe I'll buy their socks because I like their T-shirts. Their socks must be good." So it's the brand recognition and consumer trust that builds the goodwill when you have a trademark. And the bonus, and last reason, is selling on the internet. Amazon has their own ecosphere, so to speak, and they really encourage vendors to get registered trademarks. If you don't have a registered trademark, if you're a seller on Amazon, you can actually be shut down by others who do or have something similar. So Amazon doesn't mess around. They'll shut you down in 5 minutes if somebody makes a complaint. So having a registered trademark on your goods or services is very important. Just if it was only Amazon alone, that's a good enough reason to do that. So those are 13 reasons, the most important ones. There's others as well, why you should really seek federal registration. In terms of the cost, I always say, if it's worth the trouble of doing it well, you know, if it's worth the trouble of doing it, you should do it well. And doing it well means getting federal registration if you can.
Absolutely.